Division 1 is now in session.
Please be seated. Let me get my eyes on here. Okay, we're here today in Wednesday CV16. Oh, whoops, that's the wrong. Oh, no, it's the right one. Wednesday CV16-0071, ZB versus Hoeller. Each side will have 20 minutes to present their argument, and you may save any time you want for rebuttal, but it's up to you to watch your time. We are recording the argument both in audio and video, so when you come to speak, please identify yourself and your client. In a few weeks, or a few days rather, the argument should be on our YouTube channel, so you can be YouTube stars. We have read the briefs and the record, and we've conferenced the case, so we understand the facts and the issues involved. So when you begin the argument, just launch right in. Counsel, you may begin.
May it please the court, my name is Kate Miller and I represent the appellants in this matter, Daniel Hoeller and Azar Ghaffari. Now the question at issue in this appeal is what is the appropriate statute of limitations to apply to this deficiency action. As the court knows, there's two different statute of limitations, Missouri and Utah. Missouri's statute of limitations is 5 years, Utah's is 3 months. Now, the trial court chose to apply Missouri's 5-year statute of limitations based on two erroneous findings. First, that the deed of trust governed the deficiency action, and second, that the Missouri law exception in the governing law provision applied to this action.
And that's in the choice of law provision in the deed of trust.
Yes.
Correct?
Yes, Judge.
And I guess my question to you is, now that the trustee's sale has occurred and all that is taken care of, what's the effect of the deed of trust?
My argument would be that the deed of trust is essentially extinguished. Once the trustee's sale has occurred, the function of the deed of trust is satisfied. Therefore, the only remaining remedies are under the promissory note, which is why the two reasons why I believe that the trial court erred in applying Missouri law, first is because the deficiency action should never have been governed by the deed of trust. It should have been governed by the promissory note. This is well-settled law. There's the restatement, Section 229, Comment E states this. Your own court case, Parkway Bank and Trust states this. The Arizona the Arizona Supreme Court case, Cardin versus Cotton Lane states this. That deficiency actions are governed by the law of the underlying debt, which is the promissory note. Now, additionally, this point of law has essentially been agreed to by both the trial court in their application of Utah's substantive deficiency law, and in ZB in their third motion for summary judgment, where they state that plaintiff is proceeding against defendants pursuant to the promissory note, which specifies Utah law applies to that obligation. The second reason the trial court erred in applying Missouri law is that the deed of trust, even if the court decided that the deed of trust was still in effect at the time of the deficiency action, the specific governing law provision within the deed of trust, this against the property and procedural remedies language, prohibits application of Missouri law. The plain language under that section shows that it was the intent of the parties that Missouri law only be applied in the limited situation of procedural remedies against the property. Now, the classic remedy, procedural remedy against the property, is trustee's sale. And once that trustee's sale has occurred, the remaining rights are neither procedural nor against the property. Now, this against the property language, again, deficiency actions are not remedies against the property. They're remedies against the promissory note. Hardin versus Cotton Lane says this. The promissory note itself has no relationship to the property. It's merely a promise to pay money owed. The deed of trust links that promissory note to the property itself. And once the property is no longer in possession of the lender, no longer in possession of the borrower, here Mr. Hoeller and Ms. Ghaffari, the lender no longer has any rights or remedies against the property because they now possess the property. And as to the procedural remedies language, again, Hardin versus Cotton Lane supports the proposition that deficiency actions are not considered procedural matters. They're considered substantive. And as such, deficiency actions fall outside of the limited application of the Missouri law in this case.
And the deficiency action is the transfer law provision under the promissory note is only Utah, correct?
Yes, Utah and federal law. That's correct.
How does that work, though? I was confused about Utah and federal law. What kind of federal law is involved here?
Honestly, I don't think it's at issue. I don't think any party is arguing that federal law has any application here. I think it's probably just something they added in for, just to have something else in there.
Were you able to glean any legislative intent behind Utah's rather short statute of limitations?
I mean, not necessarily. It looks like I have the statute here. Hold on.
Well, it's a little odd because if the deficiency action is considered as an action on the note, why is it related in time to the trustee's sale, which is like just a remedy? It seems anomalous, that statute.
Oh, the Utah
Yes.
statute of limitations.
I mean, it seems to be a consumer protection kind of thing, but
I mean, it seems to me that the reason they tend to join these two things together is because the deficiency judgment doesn't make a ton of sense outside of the context of trustee's sale, because you can only have a deficiency judgment when some security is sold to satisfy a portion of that judgment. But I can't speak to the legislative intent based on that.
Could it just be Utah's version of an anti-deficiency statute?
Can say that again? I'm sorry.
Is a short statute of the limitations just Utah's version of an anti-deficiency statute? That if you're going to go for a deficiency, you just have a very short time to do it in.
I guess it functionally could be seen that way. It does provide an incredibly limited statute of limitations. 3 months, essentially 90 days. A lot of states have similar statute of limitations or anti-deficiency statutes. I suppose it could be seen that way, but I think it's more just an urgency on the part of the person seeking deficiency judgment should do so quickly, is the intent, the legislative intent there.
And in Utah, this applies to commercial real estate transactions as well as residential?
That's my understanding, yes. Now, it appears based on the briefs that ZB doesn't necessarily challenge the appellant's reasoning in their opening brief, but instead, for the first time in the course of this case, raises a novel argument regarding what I refer to as the challenged enforceability provision. I'd like to focus my attention on this argument unless the court has any more questions about the opening brief. Now, despite ZB's argument, the challenged enforceability provision still does not justify application of the Missouri statute of limitations here. The final section of this governing law provision, after application of Utah law and then the exception for application of Missouri law in these procedural remedies against the property, the section states that in the event the enforceability or validity of the provision of the deed of trust is challenged, then they'll apply whichever state or federal law would uphold such provision. It should be noted that this is the very first time in any of these proceedings at trial court that this challenged enforceability provision is raised in any context. I think the fact that this was not raised at trial court undermines ZB's argument because they clearly did not view appellant's argument regarding the statute of limitations as a challenge until this moment, until the briefs here are filed.
But I take it, though, your first argument is we really don't care about that provision because it's in the deed of trust, right?
Yes, that is my argument. The first reason I believe that it doesn't mandate application of the statute, or excuse me, Missouri statute of limitations is because the challenged enforceability provision only applies to the deed of trust. It doesn't apply to the promissory note. The specific language of this challenged enforceability provision allows for the limits itself to challenges brought under the deed of trust. And since this action is brought under the promissory note, the challenged enforceability provision is not applicable. And there's no such provision in the promissory note or the business loan agreement that's at issue here. My second argument, assuming that the court does believe that the deed of trust is being challenged in some way here, that the I'm sorry, that the deed of trust is still in effect here, is that this is not a challenge as intended by the language of the document to the enforceability of the foreclosure provision. These kinds of challenged enforceability provisions are traditionally used to save a provision when it's challenged in a formal way, generally on the grounds of unconscionability, violation of public policy. I listed several cases in my brief that discuss this. However, that's not what is occurring here. The plain language of this provision shows that a challenge sufficient to trigger the challenged enforceability clause would have to be a formal challenge to the legal sufficiency of the provision, which would result in the provision being found unenforceable. This is not a formal challenge to the foreclosure provision. The foreclosure provision isn't being challenged because it specifically allows for the possibility that deficiency judgment may be prohibited by law. The language of the foreclosure provision, after listing all of the remedies that the lender has upon default, states, in the event the net proceeds of such sale or sales shall not be sufficient to pay in full the indebtedness secured by the deed of trust, unless prohibited by law, grantor hereby promises and agrees to pay any deficiency thereon demand with interest. Now, this unless prohibited by law language allows for the possibility that a statute of limitations or an anti-deficiency statute would prohibit deficiency action in this case. Therefore, this isn't a challenge as contemplated by the challenged enforceability clause. The second reason, appellants are also not attempting to argue that the foreclosure provision is invalid or unenforceable. In fact, we agree that ZB has the right to seek deficiency judgment here, as long as they do so within the limited statute of limitations based on the applicable choice of law. Our argument is based on an argument that the trial court misinterpreted the plain language of the contract itself and the underlying law. The argument is dealing with parties' original intentions, not the enforceability or validity of the contract itself. It's a question of interpretation rather than validity or enforceability. I think the confusion surrounding This challenged enforceability provision arises because the byproduct of our argument would be that they would be prohibited from bringing this deficiency action. So it appears like it's a challenge, even though that's not, in fact, what's happening. Because just because the result would be that deficiency action is barred by the statute of limitations does not automatically make the argument itself a formal challenge to the enforceability of the provision of a contract. Which is why we're respectfully requesting that this court find that the trial court erred.
So the enforceability only goes to the deed by the language of the provision. The enforceability only goes to the foreclosure. It doesn't go to the promissory note.
Right,
correct?
That's correct, yes. I'm making two separate arguments that assume different facts. But yes, that's essentially my argument, is that one of my main arguments is that the promissory note governs this deficiency action. There's no challenged enforceability provision in the promissory note, therefore it can't be applied here.
Thank you, counsel.
Thank you, Judge. If I can reserve the remainder of my time for rebuttal.
Of course.
Thank you.
May it please the Court, I'm Bob Porter. I represent ZBNA, formerly known as Zion's Bank. What we have here is a choice of law under the restatement. The deed of trust explicitly said that the borrowers promised to pay a deficiency. When the borrowers executed that deed of trust, they were California residents. They were borrowing against property in Missouri and borrowing the money from a Utah bank. So their promise to pay a deficiency was stated in the deed of trust. The deed of trust says that if you challenge the enforceability of any provision of this deed of trust, whichever law, either federal law or the applicable state law, would enforce that promise will be applied.
Counsel, the concern I have with your argument is that the deed of trust was executed and the property was foreclosed upon and sold. So I'm confused about what continued viability there is in the extinguished deed of trust. The property is already sold.
Well, I understand that the deed of trust, the power to conduct a private trustee sale, has been executed pursuant to that deed of trust. I understand that. But the deed of trust contains a promise that lives thereafter, because it says that in the event the proceeds of that sale aren't sufficient to pay the debt, the borrowers explicitly promise to pay a deficiency. So that promise continues on. Without that promise, the borrowers could have argued California law, where California has a flat anti-deficiency provision.
The debtors had already promised to pay that in the note, had they not?
They promised to pay the debt, correct. But there's
Deficiency is the debt. What's left?
I agree the deficiency is that portion of the debt that's left over, but the promissory note is silent as to a deficiency. It does not say.
Well, they owe the money under the promissory note. They get it partially satisfied by executing the deed of trust and selling the property. What's left over, can't the party sue under the promissory note saying, you owe me X amount of money, and I realize part of it has been satisfied, but you owe me X minus the sales price I got under the trustee sale.
Well, precisely. That's what the suit was based on. But the suit originated with the promise in the deed of trust. The promise to pay.
The deed of trust is security for the antecedent promissory note, correct?
It is.
Then the debt arises out of the promissory note, not out of the deed of trust. And I would imagine that any deficiency for not paying on the promissory note exists because of the promissory note, not because of the deed of trust.
The promise to pay the deficiency arises from the deed of trust.
Not from a promissory note?
No, in the way the parties put the transaction documents together, they chose to say in the deed of trust, if there's a deficiency, the borrowers promise to pay that deficiency.
So if the property was not secured by the property and the deed of trust, and the couple defaulted on the promissory note, then the bank wouldn't be able to get any wouldn't be able to sue on the note.
If you're asking if the deed of trust did not say anything about it,
Well, saying the deed of trust didn't exist, and the parties just stopped paying on the promissory note. Are you saying that the bank would not be able to sue the borrowers because it didn't say anything about repayment? I'm just confused about how you say that the parties, either that the bank could not go after the borrowers without the provision in the deed of trust.
well, if you start first with the presumption that there is no deed of trust, it's a completely different case. All I'm saying here is that the parties chose in their transaction documents to put the promise to pay a deficiency in that deed of trust. And in that same deed of trust, they then put a provision that stipulated choice of law, basically. And so the exercise to seek a deficiency finds its origination in the deed of trust. And the challenge to the enforceability, the statute of limitations, is specifically addressed in that deed of trust.
Let's go back to the question you started to answer that you presumed Judge Howe was asking. Let's say the deed of trust did not have the language in there about that explicitly referenced a deficiency. So they stopped paying on the note. The property's foreclosed on. The sale occurs. There's a deficiency or a gap between what the sale realizes and the amount due under the note. Could the bank sue on the note for the deficiency?
Yes. Under Utah law, because the promissory note's governed by, it says explicitly it's governed by Utah law. The promissory note states that. So in Utah, they have a deficiency statute which sets forth when you can sue for a deficiency.
That's the 90 days.
And it's 90 days or 3 months. I think Arizona is 90 days and Utah is 3 months.
Which the bank missed in this instance.
Yes, the bank filed this action in almost 2 years after the trustee sale.
And so your argument is the fact that the term deficiency deficiency is enumerated or referenced in the deed of trust creates an additional right for the bank.
Correct. It does, and contains because you have California residents, a Utah bank, and Missouri property. So the provision in a deed of trust not only said there is going to be a deficiency, you promise to pay it, it also contained a choice of law provision in case there was any debate about what laws should apply.
But you just stated that they would be able to sue for the deficiency under the promissory note, regardless of the deed of trust, correct?
That's my understanding of Utah law. If Utah law were to apply to the action, that the bank would, without the promise to pay a deficiency in the deed of trust, the bank would still have that right to sue.
And is that is that point different under Missouri law?
Missouri law is quite different. Missouri law doesn't have any deficiency statutes at all and treats a deficiency action as one under the note, and you have 5 years to sue.
So whether Utah law or Missouri law applied, they'd still be able to sue under the note. The deed of trust doesn't matter.
Well, the deed of trust could matter. When the transaction was made, the provisions were put in the documents, and the bank and the borrowers agreed to put this promise to pay a deficiency in the deed of trust. Why they did that, it's not clear, but it's in there. The promise to pay deficiency is clearly stated, as is the choice of law provision. And as I said, the parties here there's 3 different states involved: Utah, Missouri, and California.
Thank you, Counselor.
What is your response to the assertion that you didn't raise the issue of this challenge enforceability provision until the reply brief of the appeal?
Well, my response is that's correct. We did not raise that. There was no objection to our raising it in the answering brief. It was
You're
noted.
making a separate argument.
Excuse me?
This is a separate argument, is it not?
This is a separate argument. This is what the bank is stating is that this is a correct. The trial court reached the right conclusion, and we are proffering the correct reason for the trial court reaching the right conclusion, even though the argument was not made below, and the trial court did not rely on that, obviously, in the minute entry. But if the court reaches the correct conclusion, even for the wrong reason, the appellate law is that it will be affirmed. Let me talk about the prohibited by law, because I think appellant confuses validity.
I'm sorry to interrupt you. Before you leave the last.
Sure.
I probably should caution that the notion that we will affirm even when the trial judge used the wrong reason may be kind of a discretionary doctrine rather than kind of an entitlement. It's a question of waiver and when we determine that waiver is appropriate or not. But I acknowledge that we do that.
Well, understood, Your Honor. And the point here is that the appellants did not object to it. They noted it in their reply brief, but they didn't file any motion to strike or even.
I misspoke. The argument is you first raised it in your answering brief.
Right. I understood that. But there was no objection made to that and no motion to strike that argument. So in the waiver, I think, applies to the other side. But going back to the provision that says unless prohibited by law, the appellant's interpretation of that is too narrow. Prohibited by law California would be a good example of prohibited by law. No matter what you put in your instruments, if it's California property and you have California law applying, the Cardin case is a good example of that, where the credit instrument said if there's a question about what law applies, then the California law will apply. You had Arizona borrowers, but there was California security, and the property was foreclosed on, and so the California anti-deficiency law applied. That's a prohibition. Here it's the enforceability. It's can the deficiency promise be enforced? It's not a question of it's prohibited. It can be enforced. The question is, can it be enforced because of the statute of limitations issue? And that's where the choice of law provision in the deed of trust applies, where it says whatever law that from state or federal that would apply, that would uphold the deficiency right, that's the law that will be applied. I'm open to any other questions. I'm about ready to wrap up.
No, We're fine.
The Swanson case employs the same analysis that we've employed in the answering brief on the choice of law. And the provision here is valid and effective. The parties could have chosen for themselves to have provided for a statute of limitations provision or for a deficiency, for a statute of limitations provision on any deficiency, and they did not. So it's valid and effective here because the choice of law would apply Missouri law and permit the deficiency. Thank you.
Thank you, counsel. Counsel?
May it please the court, just a couple of quick points. I mean, I think it's clear that the deed of trust does contain a reference to the deficiency action in this foreclosure provision. However, the law does make it clear that the promissory note governs deficiency actions. The promise to pay is contained inherently in any promissory note. So regardless of the specific language in the deed of trust, the promissory note still governs here. As to ZB's...
Well, the promise is sort of inherent in every deed of trust, too, isn't it? I mean, whether it's explicitly set forth, I mean, isn't the whole premise of the deed of trust that there's a promise to pay, and on the default in the promise to pay, that's what triggers the right of power of sale?
I agree that there is a promise to pay in the deed of trust. The difference being that the deed of trust is intended to act as a security instrument. It's there to link the property to the promise to pay. It's not itself a promise to pay.
But the argument is that by including repeating the promise to pay, if you want to put it that way, repeating the promise to pay the deficiency in the deed of trust, and then assigning different choice of law provisions to everything that's in the deed of trust, the bank gave itself additional rights.
Yes, I mean, I understand that that's what's being claimed here. However, I think the law itself shows that the promissory note is intended to govern deficiency actions. I think it's in there because it makes sense in the context of a sale of property. Deficiency action makes sense in the context of a sale of property. However, the action itself has to be brought under the promissory note, regardless of whether that right is explicitly stated or not.
Counsel, I asked perhaps in order for the question about suing on the note if there was no deed of trust. What about the reverse of that? If there was no promissory note, but there was a deed of trust, would a bank be able to sue on that, or do you have to have a promissory note at bottom?
I mean, it's kind of a complicated question because the deed of trust itself is only creating this security instrument. It's not, I don't know what you would be securing with the deed of trust if you didn't have a promise to pay. So I would say there wouldn't be any remedy, yeah.
Everything comes back to the promissory note.
Yes, that's my argument, is essentially the promissory note governs here, therefore Utah law should have been applied at its most condensed. Additionally, counsel's argument regarding the restatement 187, it should be noted that 187 only applies once the panel is convinced of the specific explicit choice of law, which I think that is the dispute in the opening brief, at least, is that the explicit choice of law should not have been Missouri. I think the restatement 187 upholds whichever explicit choice of law the court comes down on, but it's not itself a reason why the court should apply Missouri law. So I think a few things that become clear in this argument are based on the facts here is that ZB sat on their rights. They waited almost 2 years to bring this cause of action, this deficiency action. And then they're attempting to make an argument that the deed of trust governs this cause of action, which it's clear that the promissory note is the governing document. Therefore, we're respectfully requesting that you find that the court misapplied Missouri's statute of limitations, should have applied Utah's statute of limitations, and should not have granted ZB's motion for summary judgment.
Thank you, counsel.
Thank you, Judge.
Thank you both for your argument. We'll take this matter under advisement and we'll issue a decision in due course. We're going to stay in June, but we're going to stay at bench while the counsel for the next case comes forward. Thank you very much.